Hey, good morning or afternoon, depending on what it is. My name is Ryan Olberding. I'm a prosecutor at the Jefferson County Commonwealth Attorney's Office.
Hello, my name is Michelle Rudovich, and I'm with the Office of the Attorney General, Office of Medicaid Fraud and Abuse Control.
We're here on this webinar today to talk with you about just different aspects of prosecuting crimes against the elderly, elder abuse under Kentucky Revised Statutes Chapter 209. And just to tell you a little bit about ourselves, I'm a prosecutor that's been almost a career prosecutor my whole time. I started out as an intern at a DA's office back in 2002 to 2003. Once I was licensed to practice in 2003, I went into the Army and spent 5 years in the JAG Corps. And after I left the JAG Corps for the United States Army, I've been at the Jefferson County Commonwealth Attorney's Office ever since then. And I've been prosecuting a variety of cases, but I've been handling a large number of elder abuse, elder exploitation cases since about 2011.
Hello, I've been a prosecutor since October of 2005. I started off at the Commonwealth Attorney's Office in Louisville, Kentucky, where I specialized in a number of different types of felonies, but including crimes against seniors. I focused on abuse, neglect, and exploitation cases. And then in January of 2011, I joined the Office of the Attorney General, and I now serve as the Assistant Director and Litigation Manager of the Office of Medicaid Fraud and Abuse Control, where we investigate and prosecute Medicaid provider fraud, as well as crimes involving abuse, neglect, and exploitation that occur in Medicaid-funded facilities. Today we will be filming a series of 3 webinars that focus on KRS 209, the Kentucky Adult Protection Act. And so to focus on 209-010, the purpose and application of the chapter, the purpose of 209 is the protection of adults who suffer abuse, neglect, and exploitation, and really the coordination of services, as well as the prosecution of criminal offenses involving crimes against vulnerable adults. One of the goals is to coordinate resources to bring cases to district or circuit court where appropriate. It mandates the reporting of abuse, neglect, and exploitation, and places a duty on everyone to report abuse, neglect, and exploitation against vulnerable populations. It brings the abuse and neglect to the attention of the Cabinet, which allows the Cabinet to facilitate services to make sure that the person who is abused, neglected, or exploited receives the protective services that they need to protect the individual and to prevent the further abuse, neglect, and exploitation. The goal is also to coordinate the agency response. And it's important to note that this provision does not apply to domestic violence cases unless the victim of the domestic violence is a vulnerable adult under KRS 209, such as a grandparent or a parent.
And I just note along those lines that Michelle's laid out the purpose of the chapter, but if there's one goal I think that we have that you walk away from the training, it's that you're just aware that 209 is out there and exists. Hopefully you're going to get a lot more out of watching this than just that, but if there's one takeaway, that if you've got a case involving a vulnerable adult, that you know that Chapter 209 is out there, and that's a tool and a resource that you're going to have as a prosecutor to seek justice in cases with these specific victims.
And during the presentation today, we plan to talk about the definitions of 209 and the penalties. One of the purposes of 209 is it allows that aggravated penalty because this does involve a vulnerable population, and we want to make sure that they are protected. And as Ryan mentioned, the purpose of today's presentation is to provide prosecutors with the tools that they need to effectively prosecute these cases. And so we'll start with some of the sources of referral that prosecutors often receive for these cases.
Okay. Thanks, Michelle. There's just a number of ways you're going to get an elder exploitation case or abuse case as with any other type of case. Normally you're getting these cases, just as with your other cases, from law enforcement, but one of the key points is that sometimes you're not getting these cases as a 209 case. You're going to see these cases come in from an officer, detective as a straight-up theft, assault 4 case maybe. So you're going to have to look at the details to see if 209 applies because from our experience, there are a lot of officers and detectives out there that just aren't familiar with 209 as a charging option when they encounter assault or theft cases involving vulnerable adults. So you're going to see these a lot, and you may already be seeing them, but they're coming to you as just theft and assault cases. Some of these cases you might not even be seeing at all because they would be coming from an officer through district court as an assault case when in fact they might actually be an elder abuse case that should be a felony. So that's something to keep in mind, that your biggest source of referrals, probably local law enforcement, is going to be handling these cases, and unless they're educated, they may be just sending these through as misdemeanors to district court. Second major source of your cases are going to be APS, Adult Protective Services cases. Typically, you're going to get a lot of these cases referred to you, or at least forms in your office from APS for your review. Ideally, what will happen is that you'll have a situation in your local county where, if it doesn't already exist, where you will have a situation where both Adult Protective Services is routinely engaging with local law enforcement. In Jefferson County, we're pretty fortunate. The local Metro Police Department has a dedicated Crimes Against Seniors unit, which is essentially 4 detectives and a sergeant that are all tasked with handling these types of cases. And specific to that unit, they also have 2 co-located APS workers with them, so they have a great, almost kind of a mini fusion center, if you will, where they're able to communicate directly with the APS workers on cases. They can refer cases to APS that may not be criminal cases, where Crimes Against Seniors gets a call. They make a determination, this doesn't necessarily look like a police matter, but this is someone who's definitely in need of social services, and they can refer it to Adult Protective Services. And by the same token, they can also receive these referrals directly from APS and look into them as criminal cases when appropriate. And the other benefit is that because they're there and they're talking, they also have the ease of access in terms of information, in terms of if the police receive a report, they can go with APS and say, hey, are there prior cases involving this suspect or this victim, and look at that and have some history before they even walk into a case. And again, sometimes they may be in a situation where we're not sure what we're dealing with. Let's send APS in first, and then we can always follow up later. And typically, those APS investigations, if they're not in your file when you get them from law enforcement, are actually very useful sources of information. So that's something to keep in mind, that's a very, just a good source of information that may be out there that you're not necessarily going to get when you get a police report for an incident.
And on the topic of Adult Protective Services, the statute requires APS to notify local law enforcement within 24 hours unless it's an emergency situation. And in that case, APS is required to make all efforts to notify law enforcement immediately. Other sources of reporting that a prosecutor's office may receive concerning these cases are from the Office of the Inspector General, the Type A citations or Type B citations for cases that occur in nursing homes or long-term care type of facilities. In addition, you may also receive referrals from the office that I work in, the Office of Medicaid Fraud and Abuse Control. Our office has auditors, nurses, investigators, and attorneys, and we investigate many of the substantiated cases of abuse, neglect, and exploitation that occur in Medicaid-funded facilities. In Kentucky, the local prosecutors have original jurisdiction to prosecute these cases when an investigator brings them to their attention. But we're also trying to be proactive, and our attorneys prosecute the cases where appropriate.
And another major source of referrals in these cases are just friends, family members, and neighbors. And again, I say that they're a source of referrals, but unfortunately what you see is that the victims usually don't, in these type of cases, have a family member, friend, or neighbor who's actively involved in their life to the extent that they're usually a referral. Sometimes it's when bills start going unpaid and things of that nature, or family members become aware. And the reason that is that's what has usually made the senior or vulnerable adult a target for somebody in this case, because there's somebody who's come into their life when there's nobody else around them. And one of the red flags or hallmarks of elder abuse is an effort by the suspect to isolate the individual they're exploiting or abusing from other folks within the community. Again, and that's usually family members, friends, and neighbors. One of the ways you'll see these cases come forward sometimes is a concerned family member. And one of the things to be aware of, I think, that you'll see as a common factor in a number of elder abuse and exploitation cases, particularly exploitation cases, is if a family member is contacting you, there might very well be a tug of war going on because of the assets that are attached to that person. And so unfortunately, one of the things that sometimes law enforcement and prosecutors are put in a position to do in these cases is also determine, is this a civil case or a criminal case? And that's something we'll talk about more as we go on.
And as Ryan mentioned, sometimes these complaints come forward when bills go unpaid. And I find from my experience that's one of the most common reasons that nursing homes will make complaints regarding exploitation. And that can sometimes be a very valuable tool because they're the ones who have the access to the individuals. And when you have a resident who had funds to be able to pay the nursing home bill at admission, and then suddenly the funds have dried up and they're not able to pay the bills, sometimes that can be the red flag that can prompt a nursing home official to alert local law enforcement that someone may be the victim of exploitation. And nursing home employees, like everyone else, has the duty to report abuse. So if any abuse occurs within a facility, they have the duty to report that for abuse, neglect, and exploitation. But one of the key takeaways, I think, from this presentation is the need to educate people who can potentially be reporting sources, to educate the bank teller on what to look for, what are the red flags that someone may be exploited with their bank accounts, to educate the nursing home personnel on what are the characteristics they may be seeing in their residents, or the group homes, or the day treatment facilities, to educate local law enforcement on what makes a 209 case, what escalates a case from an assault 4 to a KRS 209 case to prosecute, what makes the victim, and to go out and talk to community groups because anyone could witness a 209 case, and it's important that people are educated and know how to pursue these cases to bring them to local law enforcement's attention, and also, even on cases that cannot be criminally prosecuted, to be watching for elders, to know that there are resources out there and that that duty does exist to report to APS so our seniors can get the resources and the help that they need.
And I really have to second that, especially the education piece, and especially I would say it's kind of surprising. I wouldn't have guessed this is going to be one of your major sources, but as Michelle mentioned, bank tellers are sometimes the front line witnesses in detecting elder exploitation. If they see someone accompanying a vulnerable adult into the bank and making multiple transactions, and they get to the point where these are high dollar amounts, typically they're the ones who may notify the law enforcement authorities or APS. And one of the concerns that we've seen is that there's sometimes just a hesitancy because of the sensitive nature of financial transactions. The bank tellers may think, hey, I'm not allowed to disclose this even though I think something's funny is going on here. And so again, as kind of Michelle mentioned, that education can be critical in terms of if you can get out there and touch base with some of the bank security officers in your jurisdiction and let them know about their obligations to report and the fact that there's actually immunity for reporting too. I would certainly second that and really highlight the bank tellers have been critical witnesses in just detecting otherwise undetected exploitation that's been going on, because again, it was a situation where you had a senior where there was nobody else involved in their life, and so their one contact with the outside world, aside from the suspect, was with a bank teller making a transaction, and had that person not spoken up, you might have had a case go undetected entirely.
On the topic of bank tellers, I find that when you look at this generation and seniors, this is the generation that generally does not have direct deposit. They may not be as internet savvy. And so a lot of times seniors will actually go into banks on a regular basis. They'll actually take their checks in. Just looking at my grandparents before they passed, they would go into a bank on a regular basis and the manager would know their name. They knew the type of transactions they were making. And I find that that's very common with seniors. And so if their transaction history had changed at all, I think the bank tellers or bank manager probably would have noticed if they had come in with someone suspicious. And so we find that that can be a great line of defense in educating bank tellers because of situations like my grandparents and other seniors that are out there that do bank at the same location on a regular basis. And on the question of who can make a criminal complaint, so KRS 209.150, really anyone can make a complaint, and anyone who witnesses abuse, neglect, and exploitation should make a complaint. But the statute outlines 3 categories. Any representative of the cabinet acting in their official capacity. So any employee of the cabinet who conducts an investigation that has come to their attention under the statute. Any person with personal knowledge, and again that goes back to the mandatory reporting requirements. And an adult who's been abused or neglected or exploited shall, of course, have standing to make a complaint regarding the actions that have occurred with them.
So, I guess in other words, basically anybody can make a complaint, essentially. I mean, it doesn't seem to limit virtually anyone. If you know about it, they can report it.
And we'll talk in a few moments about the mandatory reporting statutes that require everyone to make a complaint.
One of the key considerations for all these cases are, and it's a question you always have to ask yourself when you're reviewing any investigation or complaint, is are you actually dealing with a victim in the case that's a qualifying adult under KRS 209020 subsection 4, which lays out what the statute defines as a vulnerable adult, which is an element of all the offenses in this chapter. And you can see it by looking at the slides, but the main points are that, again, it's somebody who's 18 years or older. There's no actual, some statutes have a specific age, like over 60. In Kentucky, it's 18 or over with mental or physical dysfunctioning, which it leaves you open to a very, I would say, very broad spectrum of qualifying individuals, where you'll see folks who can range from fully competent with some minor physical conditions to folks who are almost totally incapacitated but still alive. So there's a full spectrum. And I would suggest, though, that if you have an individual that's just in advanced age but is otherwise incredibly healthy, you may want to be looking for something else beyond just the fact that their age is there that does qualify as the mental or physical dysfunctioning. But when you continue to look at the definitions, there may even be an argument to be made that someone who's of advanced age but is otherwise normal health may still qualify just to the fact that they're subject to exploitation from the frailty of their age, even though they're otherwise in good health. So that's something to think about. I don't think there's a clear answer on where you can go with that, but again, you have to have something that you can at least hang your hat on for mental or physical dysfunctioning in these cases. And then there are other categories that I guess further outline what a vulnerable adult is, that include the inability to manage their own resources, carry out activities of daily living, or protect him or herself from neglect, exploitation, or hazardous or abusive situations. And that last section really opens up the spectrum of who can qualify under there, because by virtue of the fact that they've become a victim, if they're over 18 and you're able to find evidence of a mental or physical dysfunction, by virtue of that fact alone that they've been a victim, they almost become a qualifying adult on that basis too. And the last thing the statute adds is they may be in need of protective services. That the may seems to open that up to the fact that they may not be in need of protective services, again, because you can see a full spectrum of folks who end up under 209 that include folks that are living alone by themselves, managing their own daily affairs, but can still be subject to exploitation, say from a contractor who approaches them to try to scheme them out of money and maybe targeting them just due to the fact that the contractor is aware that they're of an advanced age.
And sometimes it can be tricky to determine if someone is an adult under KRS 209 from the prosecutor's standpoint, because it's not always readily apparent on paper. And so how would you determine if someone does qualify as an adult under KRS 209? Ryan mentioned age. Certainly the older that someone is, the more likely that they could qualify as an adult under KRS 209. But there are other factors. As Ryan outlined, the 3 factors to consider about their ability to manage their own resources or carry out the activities of daily living and to protect themselves from abuse, neglect, or exploitation. But how do you actually look at it, and how do you actually make that determination? We'd like to share some sources that we've developed and have found to be useful in making that determination. In outlining whether someone is an adult under KRS 209, it's important to look at what is their overall condition. Are they an individual who has an intellectual disability that qualifies them as an adult? And in that case, some sources of information that we've reviewed before include if they are an adult day treatment facility. Do they qualify for that kind of service? Do they have a guardian? Were they in any kind of a specialized education program when they were in school? To look at the medical records, what has been documented by doctors in terms of their mental abilities or their physical abilities that may make them susceptible to abuse. And also may be important to consult with family and friends. But when one of these cases comes across your desk, it's important to start thinking about that component. How do I prove that this is an adult under KRS 209? Because some will be more obvious than others, such as advanced age. But on cases that are not as obvious on the face, it's important to also think about collecting the records to support the finding that someone is an adult under 209 if you choose to charge under 209.
Once you've made the determination that you've got a qualifying victim under 209, I think that the challenge is to figure out, how do I handle this case now? Because you could be getting the call from an investigator saying, hey, we've got a complaint, someone's taking money from an elderly victim, and they've given you enough information to make the determination that that person's a qualifying adult under 209. How are you supposed to handle these cases again? Because you have such a broad range of options. And this slide has basically 3 categories, and I have to give credit to Paul Greenwood. He's an elder abuse prosecutor from San Diego with a national reputation for prosecuting these types of cases. And at a training I'd been to of his, he kind of laid out 3 different categories of victims you're going to see in these cases. And depending on what category your victim falls into, that's going to have a dramatic impact on what type of evidence you use and maybe how quickly you move the case through the justice system and what way you go, whether district court through a normal charge and arrest or maybe seeking a direct indictment. So I'd suggest that it becomes almost a victim-focused prosecution at this point in time, not only by virtue of the fact that they're a qualifying victim under 209, which gives you 209 as an option, but also how you're going to approach the case depending on where that victim falls in under that broad spectrum of folks who can qualify as a victim under Chapter 209. So this slide should give you, I guess, a few different ways to handle these cases, or some things to be thinking about as you're kind of gathering information with an investigator and processing the case. And so some of your first questions to an investigator should focus on the status of the victim. You're just trying to determine if you have someone under Chapter 209 who qualifies as a victim, but then you're looking at, what am I doing with this case going forward? And I'll just start talking by the first category. And this is the one you're going to be most familiar with from just a traditional case. You have a lucid victim who has no mental health condition. Maybe they have a qualifying physical condition that makes them an adult under 209. And again, this is analysis you can also keep in mind for just cases where you have fragile witnesses too that are non-209 cases, where you've got maybe a witness who is fragile in terms of their health. But you have a lucid victim. You're in a great position usually because you have a victim who's able to tell you, I didn't give permission to the caregiver, family member, whoever to use my money for these particular transactions. They can give you maybe some limited information, maybe very specific information on the various accounts that they've opened and haven't opened. So the investigator has information to use to go seek out maybe through a grand jury subpoena or phone calls, just to find out what are the other financial records I can use to corroborate there's been a theft of resources here. The main point is that you've got a victim who can actually say, this is this person who caused the injury or made these transactions, and here's how I know. And then all the circumstantial evidence you get in terms of financial records, medical records, helps support your case, and basically you're building up your case around what your lucid victim has to say. But the big concern in these cases, I think, always is if you have a qualifying adult, is this someone who's going to be available to travel to court? Will their mental or physical health be the same down the road? Will they be able to testify, depending on how quickly cases move in your jurisdiction, which could be 1 year or many years down the road, depending on what the court's docket is and the priority of your case with a likely out-of-custody suspect. So that's something to keep in mind. I've got a general rule of thumb I would use in these cases. If you've got a victim who's 80 or in otherwise poor health, make sure you're thinking about moving quickly in terms of the prosecution of this case once you feel you've got sufficient evidence to move forward and you've kind of reached your comfort level. And the reason that is that some of these cases, if the investigator is out gathering medical records and financial records, sometimes it can take a long time for that information to come back. And if you've got a victim who's in fragile health, to the extent you're able to, you need to be thinking about preserving that testimony somehow. And again, I just have that as a rule of thumb. If I have victims who are 80 or otherwise poor health, I'm thinking about trying to preserve that testimony fairly quickly. But again, it's kind of a case-by-case basis. That's just what I've generally has been kind of my red flag for how I approach those cases with a lucid victim.
Well, and I think even on that note, when you have a victim that's of advanced age, even if they seem to be in good health for that age, it's still important to try to preserve their testimony when you can, because once you reach a certain age, sometimes health can become so much more fragile that by the time that a case does progress to trial, if it reaches that level, a victim who's healthy today may not be available to testify. They may hit a downturn in their health before a trial occurs and may find it difficult to come testify. So it's important to make that analysis early on to whether or not the victim needs to come and testify at the preliminary hearing to be able to potentially use that testimony later at a trial, or whether it's important to take that deposition, as Ryan noted.
And one of the things that mentioned is how do you preserve that? And Michelle's kind of hit on that a little. Again, some of this may be old ground that we're covering for folks, but the analysis quickly would be to see if you can preserve testimony as qualifying under Kentucky Rule of Evidence 804B1, which talks about former testimony. With respect to former testimony, one of the ways you can preserve that is, of course, making sure they've actually testified in an environment where they've had the opportunity to be cross-examined by the defendant or someone with a similar motive to do so. And one of the best ways to do that in Kentucky quickly is at the PC hearing or preliminary hearing. And again, this is something I didn't know about early on. This is something I kind of caused me to go through and reread the rules again because I was thinking about that. If we have a PC hearing, and these are often waived, am I still going to be able to preserve that testimony? And the answer is actually yes. Under the Kentucky Rules of Criminal Procedure, if you review its Rule for Criminal Procedure 3.10 sub 3, even if the hearing is waived, the Commonwealth can still, on demand, be entitled to a preliminary hearing for the purpose of examining witnesses, and the defendant may cross-examine the witnesses offered by the Commonwealth. So that's a quick way to do it if you're in a situation where someone's been arrested and you've got a preliminary hearing within the first 10 days coming up. That's an excellent opportunity. But one of the things you need to keep in mind is these cases are about as logistically challenging as any cases, even at an early stage, because you're in a situation there where you're actually going to be bringing your victim to court. This may be someone who has great difficulty traveling to court, may have certain times of day that they testify better or worse depending on what their health is. So it's going to involve potentially you coordinating with the detective, the victim or their family, whatever care providing agency they work with, the county attorney's office if they're going to be handling the probable cause hearing or preliminary hearing, and even the court system, and kind of getting a feel for what's the district court docket like. In Jefferson County, what you typically see in a morning is all the hearings are set to start at 9 o'clock, but if you have a case with a preliminary hearing, that hearing is probably not going to happen until 11 or 12 o'clock, and maybe even get pushed to the afternoon depending on how busy the court's docket is that morning. Those are all things to keep in mind for when you have your coordinating talk with the victim and their family, because the last thing you want to do, and it's happened to me, is have them show up at 9 o'clock at the scheduled start time and then realize, well, the defense attorney's got other cases they're handling and they're not going to be available, and the court's not even going to be available to handle a hearing until they handle their morning docket, which won't wrap up until maybe 11 or close to 12. So you may be in a situation where you're keeping the victim on standby, or just telling them, hey, don't show up until a time that's much closer to when the hearing will actually be held versus what's on the court's docket. So that's just something to keep in mind for the PC hearing, preliminary hearing, and that you do have a right to force that, but in a busier jurisdiction, you may want to consult with the county attorney if you're not going to be handling it yourself ahead of time to see if they're going to be able to accommodate you on a given day to avoid the victim making a hopefully unnecessary trip down to court. The other option you've got too that Michelle mentioned is a deposition under the Rules for Criminal Procedure 7.1 through 7.2. You can do a video deposition. Video depositions can be done, at least in Jefferson County. The judges will make their courtrooms available for us to do a deposition. The judge doesn't have to be present for it. We'll usually have one of our detectives come in who can act as a notary and swear in the witnesses and take testimony on video equipment in the courtroom. One of the other benefits to the deposition is if you can't get the victim to court because their physical health may prevent them from traveling to court easily, you can coordinate for a video deposition outside of court. And the other thing to keep in mind that's a benefit of the video deposition is you can coordinate for an out-of-court deposition, but depending on your jurisdiction, it might take some time to actually get the defense attorney lined up, the victim and the defendant to do an out-of-court statement. And so if you've got an in-custody defendant, that's going to be a real logistical challenge to make that happen. Usually this is a scenario where you do have an out-of-custody defendant who can be present. And again, why do you want the defendant present? So you can preserve testimony in a way that's going to satisfy the confrontation rights of the defendant in the event you actually need to use this at trial. And one of the things to keep in mind too is with the deposition and the PC hearing, you're not forcing the defendant or the Commonwealth to agree to that testimony being admissible at that time. You're just trying to preserve it so if down the road under Rule 804, the witness, usually the victim, is unavailable to testify, you can actually have an argument to make that you have qualifying testimony under Rule 804. And one of the things I just want to note about 804 is they specifically address what unavailability means for admissibility of testimony, and that specifically includes situations where the witness has a lack of memory about the subject matter, or they're unable to be present because of, in the worst cases, death, or some other sort of physical or mental illness or infirmity. And as Michelle mentioned, you're going to have cases where your victim might remember at the time they report, this is what happened, but maybe weeks, months, or a year down the road, their memory is not going to be what it was, or they may have no recollection at all of the event in question. So that preliminary hearing is a great opportunity to try to get that testimony preserved. And one of the things I've noticed in starting to do this more frequently recently is that by doing this early on, it provides less of an incentive to delay the case, because I think in the back of every defense attorney's mind, they understand that if they can delay this to the point that the victim is unavailable, then that makes their case a little bit better. In some cases, depending on your case, it may prohibit you from even being able to prove your case. That's not the case in all cases, but that's something to keep in mind. Where I've been demanding a PC hearing before early on, I've had defense attorneys come to me and say they want to resolve a case quickly through the rocket docket in Jefferson District Court on a case that I expected might drag on for a year, maybe more, because they knew we were ready to go. And a case that might have been sitting in my office for a year or more was resolved within just a matter of days very favorably, because we had the victim available and ready to have the PC hearing. And instead of going through that, they wanted to just address talking a plea that morning.
There are a number of strategic considerations in determining whether you would like to put your witness on, your victim on, for a PC hearing or to later take a deposition. In some jurisdictions, there seems to be a lag between when a case is presented to the grand jury to when the defendant is ultimately arraigned. And once you are in circuit court, that would provide an excellent opportunity to take the deposition. But if you know that you're going to experience a delay in that PC hearing date to when you're actually in circuit court to be able to move for the deposition, then going forward with the PC hearing can be ideal to preserve that testimony, especially if you have concerns on your victim's health, even if it's just over the course of the month or the few months between when you're in district court to circuit court. The PC hearing also requires the prosecutor to really get to know the facts of your case a lot faster than you may have otherwise. I know in a lot of jurisdictions, the Commonwealth Attorney's Office does not become involved in the case until after a case is waived from district court to circuit court, to when it's ready to go to the grand jury, or to when the local law enforcement brings the case to their attention. And so ultimately it requires a lot of coordination with the county attorney's office to be able to be ready to have the PC hearing and to make it effective, whether it's the county attorney's office that conducts it or the Commonwealth Attorney's Office who would ultimately prosecute the case if it comes up to circuit court through the grand jury proceedings.
That's a great point. When you're at the PC hearing, sometimes you really do have limited knowledge of what the case is, especially if it's a case where you were particularly concerned about maybe a lengthy delay in getting bank records or medical records. But just as a rule of thumb, what I try to ask the investigators or the folks doing the PC hearing is, at a bare minimum, get what you would normally want, that victim IDing the defendant as the source of the injury or the person responsible for the theft, and identifying the transactions in question to the extent they're able to, and acknowledging that there was never permission for their funds to be used in the way that they were used. And that's important, especially if it's a case where you have a suspect who may have had a power of attorney document or might have been a close family member, where it wouldn't be unreasonable for someone to assume that they actually had permission, except in cases where you have the victim present in court saying, I never gave him permission to use those funds. So that's just something to keep in mind in terms of at bare bones. That's what you're hoping to at least get at the PC hearing, and then you can build your case around that down the road. The next category of cases is when you have the unclear status, where your victim may be somewhere between competent to testify and not competent. You're just not sure, but you want to make sure you've actually get the testimony. Again, I think the best rule of thumb is to try to preserve that if you can, and really the best way to do that is to talk with the detective, the family members of the victim or caregiver, and the victim yourself, and kind of get an idea, is this someone that if I call them to testify in the afternoon, if I can schedule an afternoon PC hearing, will that be better for their health and their ability to recall facts? Or are they someone who's more of a morning person, where we need to get them early in the morning on the record and testifying before they get worn out after a few hours? And just the time of day in some cases could make all the difference in the world in terms of what sort of testimony you're going to get. One of the things to keep in mind in those cases too, that you don't necessarily have where it's very clear that you have a lucid victim with no mental health issues, is to try to walk through some of the questions that you might have the court ask down the road to determine competency. So that's one thing to keep in mind, is ask questions that are geared towards competency, towards their ability to recall facts, understand an obligation to tell the truth, as some of your preliminary questions in the examination of that witness at a PC hearing or at a deposition, just so when down the road, if you're in a position where the victim is unavailable to testify, then you can also argue to the court, this is also a victim who is, not only met the requirements of the former testimony exception to hearsay, but they also are competent witness based on our questions. And these are cases where you may have to have an expert witness also testify to support your argument that the witness is competent, and they can provide the court with information on the victim's physical or mental health condition and how that would impact some of those factors under competency in terms of their ability to recall facts and communicate, and just otherwise know what their obligation is to tell the truth. So that's just something to keep in mind. And it's kind of a double-edged sword in these situations. As I note on the slide, if you have someone who's in a bad condition, you might not ultimately get to use their testimony, but that also helps prove their vulnerability but again, to the extent they're actually more, I guess, better able to testify, then it does make them look less vulnerable. But either way, I think from our perspective as prosecutors, we're trying to get the truth out there, and that's one of the best ways to do it, is to preserve that, or at least make the attempt and acknowledge that that may make your case better, or it may expose some weaknesses in your case too to the defense as well, particularly if you have someone whose health is questionable or their ability to testify is questionable. But again, there are ways you can argue around that, and it really all depends on how critical that person's testimony is to your case.
Ryan had raised a number of factors in determining whether a victim will be competent to testify. And one of the factors that Ryan raised is looking at whether there's a time of the day that is better for the victim, where maybe they're more competent, maybe in the morning they're more groggy, for instance. Other factors to consider would include, are they on any medication that can sometimes impair their memory? And is that a medication that could be altered for that day, such as, are they on a pain medication for a condition that they have? You certainly want your victim to be comfortable, and you want to make sure that they have the medication that they need. But if there's a period when they take their medicine that within a certain time period that they know that they're going to have more vivid memories, or that during some points that would cause them to be more groggy, that may be a consideration. Or for victims who may be more advanced age, is this a victim that takes a nap at a certain point of the day? If you talk to family and you know that that victim takes a nap every day at about 1 o'clock, then perhaps trying to schedule a hearing in the morning before a designated nap time or some point of the day that would impact their schedule may be advisable to have the best testimony that you could have.
Last category of cases are where you've got a victim who's incapacitated, or maybe there's an unexpected death that occurs at some point in time in the proceedings. And if you handle these cases enough, it's going to happen to you, because it's happened to me where the investigators will bring you a case that they didn't get until after the victim was deceased. Maybe in the course of the investigation, they've interviewed the victim, and then there's a sudden health condition where they take a turn for the worse, and you end up getting some statements from friends and family members and the detective, but they end up being deceased before you have the opportunity to get a PC hearing or a deposition. And again, it can happen in any case, really, when you think about it. It's just that these cases are the ones where you have a very good idea on the front end that, yeah, this is somebody that might not be available for trial, again, whether it's death, memory issues, or just their health may prevent them from traveling from their home or whatever facility they might be in to court to testify. So in any event, you will have those cases come up, and they're among the most challenging, but there are certainly ways to prosecute them, and we've successfully prosecuted cases in the past where we have unfortunately had victims that were deceased on the front end of the investigation before their testimony can be preserved. It makes it much more difficult, but it's a challenge that, depending on the nature of the case, can be overcome. One of the things I would note is, it's on the slide, you end up with almost sometimes an entirely circumstantial case, except maybe in cases where the accused might confess to the offense even though the victim's deceased down the road. In that kind of scenario, you end up looking at a few different factors, and these are some factors you might want to discuss with law enforcement, and just be thinking about yourself in these cases when you've got an entirely circumstantial case. I mean, you're ultimately asking yourself, do you think you can prove these transactions were made without the victim's permission, or do you think that these are injuries that were caused by this particular person, and you can prove that without the victim's testimony to be being available? One of the questions I always ask the detectives is, what's the relationship between the suspect and the defendant in these cases? And these are factors that you're going to consider in the other categories as well. I just highlight them here because this is all you're going to have really potentially to work with for your trial in terms of evidence, because you're in a position where you might not have any direct evidence or might not have an admissible statement of your victim available to play. So you're focusing on the type of relationship between the suspect and the defendant. Is this someone who's a new friend, a family member who's close, or a longtime friend that's being accused of maybe exploitation or abuse in these cases? One of the other things is you're looking at the timeline of the victim's health and how that lines up with the suspect coming into their life. Is there a correlation between that's significant? If there are financial transactions involved, can you correlate the timeline of the transactions increasing maybe with a decline in the victim's cognitive health? That's something to consider too, where you're looking at the timeline from the medical records and the financial records and kind of seeing how those overlap with each other. Another thing you're kind of considering in these cases too is how big is the asset, that pie essentially of assets that the victim had. Is this someone who had $1 million estate, and so a couple $1,000s to a close friend wouldn't necessarily be out of the ordinary, or might be the equivalent of me giving $1 or $2 to somebody. So, or are you in a situation where, you know, $1,000 is $500 more than the person had to spend that month, and they have bills going unpaid as a result of that for critical items like medical care, rent, utilities, that also coincide with that person becoming involved in their lives. Again, those are factors that are just things that you want to consider, so you don't necessarily write off a case because the victim's deceased and you won't have that information, but you really have to take the time to assess, can you make the argument or presenting your case in chief enough circumstantial evidence that you can make a strong argument to a jury that there was exploitation that occurred here, and these are the type of transactions you wouldn't have normally expected anyone, especially maybe a victim in this case with this person, to authorize. One other thing I just want to note too is that, again, all's not lost. Sometimes you're not going to end up with just a circumstantial case. I would say Carey 806 is probably one of my favorite rules of evidence. I think everyone's probably got one maybe, but this is an interesting one, and I didn't even understand it for the longest time. I had heard about it when I went to a conference for prosecutors in terms of a way it could be used. And what Carey 806 is attacking and supporting the credibility of a declarant of a statement. But essentially, just so you know what the rule means, because when you read it, its plain reading really isn't clear. But if you're prosecuting one of these cases and the defense is, well, the victim gave me permission to make this, in the defense at some point in time, and there's case law that may suggest the opening statement's enough, but if they elicit a hearsay statement from the victim, basically from somebody else who's on the stand, and they're able to elicit that information that the victim gave the defendant permission to take the funds, that under that rule may open the door to you introducing any hearsay statements you have that may have been collected by an investigator prior to the victim's death, or you may be able to introduce a statement that that person made to a friend or family member if the defense opens the door during the course of the trial. So in some cases, you may have a position where you just have to wait and see what happens at trial, and that's a hard position to be in, but that's something that's out there, and it's a great tool for prosecutors. It's something that could be used potentially against us too if we're eliciting hearsay testimony. But again, it's a rule I think that's just not generally understood out there, and it's something that you may also be relying on the judge understanding it too. So if this is something you're concerned about or you think might come up in an exploitation case where there's potentially going to be a permission defense raised, you should be prepared with whatever supporting case law or arguments you have in the event that comes up. And just one thing to note on Rule 806, one way this can potentially come up too is if you're in a trial and the defense attorney elicits a hearsay statement made by the defendant, suddenly it's as if the defendant has gotten on the stand and you're allowed to impeach that hearsay statement, which if you're dealing with a defendant that's got a prior felony that would be admissible if they had taken the stand, and in most cases you're probably not expecting the defendant to take the stand, but if that's inadvertently admitted by the defense attorney, suddenly you're in a position where you can ask to approach and let the court know, Your Honor, the defendant has just elicited hearsay testimony of the defendant. It's an admission for us, but it's hearsay to them, so if they elicit a hearsay statement from one of the Commonwealth's witnesses or one of their own witnesses, that may be an optimum time to approach and ask to introduce a prior felony conviction at some point in time of the defendant. based on Rule 806. Again, it's a rule that's not generally understood, but essentially it's something that allows you to address a permission defense in exploitation cases, and then just in general address cases where, again, I think this is the most useful from a prosecutor's perspective, cases where the defendant actually elicits a hearsay statement of his own, and then that may give you the opportunity to introduce a prior conviction. So I encourage you all to review some of the cases on 806 and some of the evidence horn books out there. It's a very interesting rule, and this is a particularly, I guess, potentially fruitful area for a prosecutor to use that rule in an exploitation case where you've got hearsay statements available of the victim, but you're in a position because of their incapacity or their unexpected death where you were never able to preserve them as former testimony through a deposition or through a PC hearing. So again, keep that in mind. If I could stomp my foot here, I would, but I would suggest that that's one of the more important points that you can get in terms of just sorting out these cases, is keeping in mind the various categories we talked about of victims and the need to preserve testimony, and the fact that even if you don't get around to preserving the testimony for any number of reasons, the case isn't necessarily over yet. You still have other options.
As Ryan just noted, there are a number of considerations when we have cases under KRS 209. What I have found is when I prosecute a 209 case, I always look at the case, what evidence do I have today? If my victim takes the stand, how strong will it be? And then in the back of my mind, I'm always thinking about, let's say that my victim is unable to take the stand. Let's say that they're ill or there's some other reason why they can't make it to a trial. What else can I do to corroborate the case? Or what else can I do to work with local law enforcement to corroborate the case? Is there a family member that can come in and testify? Is there a change in conditions, such as if it's an exploitation case, has there been a change in their baking patterns? If there was a new power of attorney that is now accused of exploiting the victim, was there a change in the spending habits under the last power of attorney to this power of attorney? Did they not make gifts, if that's the defense, to the power of attorney that they had previously, where now there's the claim that they're making gifts and that's where the money is going? So what are the circumstances that we can look at to establish that there is that change in pattern? Or if it's an assault case, is there a medical expert that we could consult with? There are forensic doctors, such as Dr. Smock in Louisville, who can analyze injuries to help make a determination of, is this an injury that occurred through a specific cause, or such as what the defense is putting forth, or is it an injury that's more consistent with some type of an assault? And so those are all factors that I'm considering when I receive a case, when it first comes across my desk, and I'm looking at it to see what can I do to corroborate or to enhance the case if the victim's unable to ultimately take the stand. And so we've talked about the definition of what an adult is under this statute, and for purposes of today, we're primarily talking about crimes against seniors. However, it's also important to note that this analysis also would apply to those who are falling under 209 because of an intellectual disability. And so any adult under 209 is really the core of what we're talking about today, but we do have a special focus on crimes against seniors for this presentation. And in terms of numbers, I was recently reviewing the 2015 Kentucky Elder Abuse Annual Report, which can be located on the Cabinet's website. And it's a great report that highlights some of the various agencies that work on crimes against seniors, either through the coordination of protection efforts or the prosecution of crimes against seniors. And in the report, it outlines the numbers of substantiated findings by Adult Protective Services. So for ages 18 to 59 in 2015, for substantiated adult abuse findings, there were 151. For substantiated neglect by caretaker findings, there were 157, and exploitation findings were 102. So those are, of course, spread out throughout the Commonwealth, which would appear at the Commonwealth and County Attorney's offices on those 115s that are sent in by Adult Protective Services. And then in terms of the numbers for ages 60 and over, there were 160 substantiating findings of adult abuse, 252 substantiated findings of neglect by a caretaker, and 287 substantiated findings of exploitation. Of course, the number of calls that Adult Protective Services receives is much higher, a number being unsubstantiated, a number also being spouse or partner abuse, and by far the largest number, sadly, is self-neglect that is also investigated by Adult Protective Services but would never come across the desk of a county or Commonwealth attorney. And in speaking of caretakers, the next slide follows 209.020 subsection 6. And this gives the definition of who is a caretaker under this act. So under KRS 209, a caretaker is an individual or an institution who has been entrusted with or who has the responsibility for the care of the adult as a result of a family relationship, or who has assumed the responsibility either in a volunteer role or by contract, employment, legal duty, or agreement. And so it's a very specific definition of caretaker, but it's important to note that it could be family or a volunteer role, not just the employment position. And this concludes the first segment that we are filming today. The next segment that focuses on KRS 209 will focus on the definitions. What is abuse, what is neglect, and what is exploitation, and the penalties involving them.